In this lecture, we'll discuss the 2000 election controversy and the Supreme Court's famous case in Bush versus Gore. Now, the 2000 election controversy is extremely complicated. It involved multiple lawsuits, but we're going to talk about the final holding in Bush versus Gore and its implications for election law. But I want to give at least some background to what was happening in the 2000 election controversy so that you can situate the case and the larger facts that surrounded it. So in the run-up to Bush versus Gore, there were a lot of conflicts over different aspects of the 2000 election. On the day of the election, there were concerns about a particular ballot in Palm Beach County called the butterfly ballot, which led some voters to be confused as to who they were voting for. I happen to have one of those ballots right here, and this is the Palm Beach butterfly ballot from 2000. And one of the sources of confusion was that people who selected the second circle on the ballot thought they were voting for the second candidate over here, who's Al Gore, and they would push through. But then, as it turned out, that was the circle that referred to Pat Buchanan. And so hundreds, maybe thousands of people voted for Pat Buchanan with the intent to vote for Al Gore. While the voter confusion related to the butterfly ballot may have significantly affected the outcome of the election, it wasn't something that the parties could figure out a way to litigate. Instead, the issue that really became Bush versus Gore had to do with whether the punch card ballots that Florida was using were accurately registering votes. Because in addition to the voter confusion from a ballot like this, part of the question was whether voters were able to press through these ballots in order to register a vote on these punch cards. And, if you do not end up completely perforating the punch card and having what are known as the chads going through, then the machines might not register a vote. Now, there could be all kinds of reasons why a particular punch card does not register a vote. It could be because the voter didn't put the ballot all the way down across these little pins. It could be that there was all kinds of buildup behind the mechanism so that you couldn't go through the ballot to accurately cast a vote. It could be that the machine was broken. And so the question was, could a manual recount of these ballots discern the intent of the voter such that votes that were not accurately captured in the initial machine count of the ballots, once you looked at them, could you easily discern that actually some of these votes were clearly cast for one or the other candidate? And so in Bush versus Gore, there were lawsuits filed on every aspect of the electoral process because the number of ballots that was in dispute was below 500 at times. And so you had all of these lawsuits dealing with everything from mail ballots to erroneous felon disfranchisement, all kinds of aspects of the electoral system. But the central issue that became Bush versus Gore was the malfunction of these punch card voting machines. And pursuant to state law, Al Gore's team asked for hand recounts in the heavily Democratic counties. And then eventually the Supreme Court of Florida ordered a statewide count of what are known as undervotes. So now you need to understand a little bit what's the difference between an undervote and an overvote. An undervote is a ballot where no vote was captured. So for example, the presidential race would be blank. An overvote is where more than one candidate was voted for. So if someone voted both for Gore and for Buchanan, you don't know who they were actually voting for, so that ballot would be disqualified. So what the Florida Supreme Court eventually ordered was a statewide recount of undervotes to see whether through an analysis of those ballots, you could discern the intent of the voter on certain ballots where the machine was unable to accurately register a vote. So as we approach Bush versus Gore, I think it's important to understand the constitutional and statutory material that was relevant in that case. And so ultimately, Bush versus Gore is a 14th Amendment case. It is an equal protection case, similar, and as you'll see, citing cases like Harper versus Virginia Board of Elections and Reynolds versus Sims, which we've dealt with in this course. But in the litigation, concerns about equal protection, concerns about due process, both grounded in the 14th Amendment, came up. In addition, there's Article 2, Section 1, Clause 2 of the Constitution, which says that each state shall appoint in such manner as the legislature thereof may direct a number of electors. This is, as we'll learn, part and parcel of what's known as the independent state legislature doctrine. But the question here was whether the state Supreme Court had departed from the procedures and the substantive requirements of law as specified by the legislature. Then there's the Electoral Count Act, 3 U.S.C. Section 5, which came out of the controversy of the 1876 elections. So let's just say that this statute is not exactly a paragon of clarity for dealing with intense election disputes in the modern age. But what that provision provides is that if any state shall have provided by laws enacted prior to the date fixed for the appointment of electors for its final determination of any controversy or contest concerning the appointment of all or any of the electors of such state, and such determination shall have been made at least 6 days before the time for the meeting of the electors, such determination, made pursuant to such law, shall be conclusive. So that's a complicated statute. But for our purposes, the key feature here is that this is what's known as the safe harbor statute. That if a state has an election that takes place according to rules that are enacted prior to that date, well, then the results of that election will be seen as presumptive with respect to the slate that will eventually be sent to the House of Representatives, the slate of electors for the Electoral College. And so while it's a complicated statute, the key feature here is whether that safe harbor date is constitutionally relevant for how the Supreme Court should deal with the controversy in Bush versus Gore. So as we think about Bush versus Gore, there are 3 stages at the Supreme Court that are relevant. The first is a decision called Bush versus Palm Beach Canvassing Board, in which the court 9-0 remands to the Florida Supreme Court on whether, on trying to get clarity from the Florida Supreme Court on how it was basing its decisions with respect to the early stages of the recount. I mentioned this earlier case because the issue of the independent state legislature doctrine, which subsequent to Bush versus Gore has now become quite important, that Bush versus Palm Beach Canvassing Board kind of raises the issue as to whether that independent state legislature doctrine should be taken seriously. Second, after the Florida Supreme Court issued its decision requiring a hand recount of the ballots throughout the state, the Supreme Court issued a stay to prevent that from going on. Because of that stay, that basically meant that a recount was not going to be able to be completed by the date of the safe harbor deadline that was provided by 3 U.S.C. Section 5. And then finally, what we'll spend most of our time talking about here is Bush versus Gore itself and the different components of that decision. And so let me make clear what the different components of the Bush versus Gore opinion are. First, there is a 7-2 holding that the recount that was being prescribed by the Florida Supreme Court violated the Equal Protection Clause. It's the 5 conservatives plus Justices Souter and Justice Breyer who hold that there was a violation of the Equal Protection Clause. But when it came to the question as to whether the Florida Supreme Court should have another chance to conduct that recount, that's a 5-4 decision, which shuts down the recount, refuses to remand the case to the Florida Supreme Court because there wasn't enough time to conduct a proper recount by the time of the safe harbor deadline in the Electoral Count Act. And then there's this 3-justice concurrence in Bush versus Gore, authored by Chief Justice Rehnquist, joined by Justices Scalia and Thomas, on the independent state legislature doctrine. In addition to the equal protection violation and the equal protection holding which they joined, those 3 justices would have found the Florida Supreme Court to have been violating the requirement in Article 2, Section 1, which required that each state, in a manner determined by the legislature thereof, shall appoint a number of electors. So now let's dive into Bush versus Gore and start by looking at the precedent that is cited. Many people, I think, were surprised at this first sentence in Bush versus Gore, which is that the individual citizen has no federal constitutional right to vote for electors for the President of the United States unless and until the state legislature chooses a statewide election as the means to implement its power to appoint members of the Electoral College. Now, this shouldn't be a surprise to you because as we dealt with in Harper versus Virginia Board of Elections, the earlier cases that when dealing with poll taxes, we know that the court has not said that there is a right to vote in the Constitution, but rather, once a state creates elections, that it cannot discriminate among people in its allocation of the right to vote. And so if you look in Bush versus Gore, there's actually very little that one can cite. But the citable sentences are that first one that I mentioned, and then the second, which is the precedent that the court is relying on for the equal protection holding. And the court says, echoing Harper or quoting Harper, having once granted the right to vote, the state may not, by later arbitrary and disparate treatment, value one person's vote over that of another. The right of suffrage can be denied by the debasement and dilution of the weight of a citizen vote, just as effectively as by wholly prohibiting the free exercise of the franchise. Remember, Harper is the poll tax case that's cited here, and then Reynolds versus Sims is one person, one vote. There's also another one person, one vote case, Gray versus Sanders, which is later cited in the opinion, though not many other voting rights cases are cited. But the point is clear here, which is that for the same reason that in, say, the redistricting cases, the one person, one vote cases, you can't value one person's vote over that of another, so too here, voters who cast, say, defective punch card ballots in one part of the state cannot have their vote valued more than someone who did the exact same thing in another part of the state. And so through these quotes and through this precedent, the court is trying to emphasize the equal protection holdings of those earlier right to vote cases. So just to get into a little bit of the details with respect to the equal protection holding, some things that the Florida Supreme Court had done was they ordered a tabulation by hand of 9,000 ballots from Miami-Dade County, the inclusion of a certain number of ballots from Palm Beach and Miami-Dade, which would have been resolved on remand from the Florida Supreme Court to the local trial court, as well as mandatory manual recounts in all Florida counties where undervotes had not yet been subject to manual tabulation, and those recounts would be conducted under the intent of the voter standard that was in Florida law. And that standard is not unfamiliar to other states, but the idea is that in a recount, in a manual recount, you look at the ballots to see whether you can discern the intent of the voter from the markings that are on the ballot. Because sometimes a ballot, will not be completely clear to a machine, for example, where the chads might not have been completely perforated and punched through. But if you look at the ballot and you see that no chads have been punched through, but that there are little indentations on particular offices, you might be able to surmise that those were the offices that the voter tried to vote for. And so the intent of the voter standard is the touchstone of the Florida Supreme Court's decision. Now, the Florida Supreme Court relied on intent of the voter because that is the standard that was in Florida statutes. But that is what the Supreme Court really strikes down in Bush versus Gore. And so it explains why the intent of the voter standard is it's imprecise and not a good guide for resolving the equal protection challenge. As the court says here, the question before the court is not whether local entities and their expertise may develop different systems for implementing elections. Instead, we're presented with a situation where a state court with the power to assure uniformity, has ordered a statewide recount with minimal procedural safeguards. When a court orders a statewide remedy, there must be at least some assurance that the rudimentary requirements of equal treatment and fundamental fairness are satisfied. Now, there's a lot there in that quote, but the basic idea here is that the words intent of the voter are simply too vague, that we don't know what the direction is to these individuals who are now going to be studying the thousands of votes at a time to figure out how do you determine the intent of the voter? What should be the standards that one applies? Like as we call dimpled chads, where there's just like a little bump on the ballot. Should that be interpreted as a vote? What about swinging chads or hanging chads, where part of the chad is on the ballot is perforated, just a little sort of piece of paper, so that it's swinging or hanging? Should those be included as legitimate votes. And so what it's trying to say here is that if all you have is intent of the voter, then there's a risk that dangling chads in one part of the state are going to be counted as legitimate votes, but not in another part of the state, and that we need something much more specific and definite. So the vagueness of the intent of the voter standard is what is seen as creating the equal protection violation in the Florida Supreme Court's order to the local trial court to conduct the statewide recount. And so you have 7 votes on the Supreme Court for the notion that there is an equal protection violation here. Where the Justice Souter and Justice Breyer jump off from the majority as to whether this is a resolvable problem. From their perspective, you could remand this back to the state Supreme Court, and they could still conduct a recount, perhaps not with the intent of the voter standard, but with something more specific. But one of the most controversial quotes from Bush versus Gore is the effort by the Supreme Court seemingly to restrain that case to the facts of that case only. So what the court says in that case is, the recount process and its features here described is inconsistent with the minimum procedures necessary to protect the fundamental right of each voter in the special instance of a statewide recount under the authority of a single state judicial officer. Our consideration is limited to the present circumstances, for the problem of equal protection in election processes generally presents many complexities. So part of the question here is that, is this a ticket for this day and train only? Is this a decision that only applies to the unique situation with Bush versus Gore? As the court tries to emphasize that the requirement of a more precise standard than intent of the voter only really applies when you're talking about a statewide recount under the authority of a single state judicial officer. But it's not clear why it should apply only in that case. Why shouldn't this rule of equal protection, for example, apply to situations where some parts of the state are using defective punch card ballots and some parts are using modern electronic voting machines? Should that be an equal protection violation? The court here seems to suggest that no, it's really the intent of the voter standard that is the problem when you could have come up with a more definite standard. As I mentioned, the most controversial part of the case is also in some ways the most complicated. Why is it that the court is not allowing the recount to proceed so that the state Supreme Court could come up with a more definite and precise definition of intent of the voter? This is where Justices Breyer and Justice Souter don't join the majority. And the reason that the court gives is that the Florida Supreme Court had said in an earlier opinion that the state intended to take advantage of the safe harbor provision, the electoral count act that we described earlier on, and that, frankly, that date had just occurred at the time that the court was issuing its Bush versus Gore decision, so there was no time possible for the court to remand to the state Supreme Court, conduct a recount, and then take advantage of that safe harbor deadline. Now, critics of this position would say that, look, it's not as if the votes wouldn't end up being counted or that the electoral slate would not be sent to the House of Representatives. It's just that these legal presumptions that were in the Electoral Count Act, the state wouldn't be able to take advantage of those presumptions. But for the court, Supreme Court, U.S. Supreme Court, they said the Florida Supreme Court made clear that the Florida legislature wanted to take advantage of that safe harbor. And so therefore, time has run out, and George Bush is effectively the President of the United States. One of the most confrontational sentences in Justice Stevens' dissent is the one that a lot of people pay attention to that I've reprinted here. And here's what he says, is what must underlie petitioner's entire federal assault on the Florida election procedure is an unstated lack of confidence in the impartiality and capacity of the state judges who would make the critical decisions if the vote count were to proceed. Otherwise, their position is wholly without merit. The endorsement of that position by a majority of this court can only lend credence to the most cynical appraisal of the work of judges throughout the land. It is confidence in the men and women who administer the judicial system that is the true backbone of the rule of law. Time will one day heal the wound to the confidence that will be inflicted by today's decision. One thing, however, is certain, although we may never know with complete certainty the identity of the winner of this year's presidential election, the identity of the loser is perfectly clear. It is the nation's confidence in the judge as an impartial guardian of the rule of law. Now, if you look at that quote, now famous quote from Justice Stevens' dissent, what he's trying to convey is not that, say, the U.S. Supreme Court justices in Bush versus Gore were behaving in a partisan way, but that their refusal to allow the Florida Supreme Court to conduct a recount either under the intent of the voter standard or to remand with greater instructions, that the U.S. Supreme Court's treatment of those state judges is what will lead to a lack of confidence in state judges to resolve election controversies like this. Now, let's talk about the implications of Bush versus Gore itself. So this, what seems like a very rigorous equal protection holding, has not really translated to other settings, either in election law or outside of election law. And so the notion that it was a ticket for that day and train only seems to have pretty much stayed true. In fact, for many years after Bush versus Gore, the case wasn't even cited. The issue that was live in Bush versus Gore that remains live today as we approach 2023, though, is this idea of the independent state legislature doctrine. Now recall, the independent state legislature doctrine is the notion that state legislatures have a particular position under the U.S. Constitution because of statements like those in Article 2 that state each state, in a manner determined by the legislature thereof, shall appoint a number of electors. And so if you believe that state legislatures cannot, for example, be constrained by state constitutions or by state judiciaries, or even sort of misinterpretations by state executive officials like secretaries of state, well, then the independent state legislature doctrine is the way to try to elevate the decisions of the state legislature above those other branches of government. This in part was relevant to the insurrection and events surrounding January 6th, where some of the advocates for overturning the electoral slates that had been sent to the Electoral College and then to the U.S. House of Representatives, that the argument was, no, let's let the state legislatures rethink whether those slates are an accurate representation of who won in those states in the 2020 election. In addition, there was a case in 2015 called the Arizona State Legislature versus Arizona Independent Redistricting Commission case, which dealt with the context of this independent state legislature doctrine in the context of redistricting disputes related to independent commissions, because the argument was made that an independent commission created by, say, an initiative process is not the legislature under the independent state legislature doctrine. And similarly, in this case that the court will decide in 2023, Moore versus Harper, the court has to decide whether a state constitution, as interpreted by a state Supreme Court, can constrain a state redistricting plan for Congress, because there's an analogous clause which says that the time, place, and manner of congressional elections shall be determined by a state legislature. So this independent state legislature doctrine, which was given real power in the litigation over Bush versus Gore, but which had never commanded a majority of the Supreme Court, lives on from Bush versus Gore potentially to this day. The 2000 election controversy also had other consequences related to statutory law. Because of all the controversy surrounding the 2000 election, Congress eventually came together to pass the Help America Vote Act, which is in many ways the most significant voting rights legislation since the Voting Rights Act of 1965. The Help America Vote Act created the Election Assistance Commission. It required states to adopt voter registration databases statewide so that voter registration was not just going to be kept by counties, but there would be a consistent database at the state level. It guaranteed what are known as provisional ballots, so that when you try to go vote in the polling place, and if they say you're not on the rolls, or if you don't have the right ID, or some other problem with your registration, you now have a federal right under the Help America Vote Act to cast a provisional ballot, which could then later be adjudicated to see whether you are an eligible voter or not. But with respect to all of these problems related to voting technology in the 2000 election, the Help America Vote Act provided over $1 billion, actually several $1 billion, for the replacement of punch card machines like the one that we saw in Florida with more modern electronic voting machines. And finally, one thing the Help America Vote Act provided was for the first voter identification provision in federal law. Now, this is just for first-time voters who registered by mail. And it's not like a Crawford photo ID requirement where it's a very restrictive photo ID. Pretty much any document of the 30 or so that the statute mentions can be enough in order to validate your registration. And these include things like utility bills or other kinds of forms of identification, not necessarily ones that contain a photo. But out of the ashes of Bush versus Gore and the Help America Vote Act, the contemporary debate over voter ID was joined. And so in the years subsequent to HAVA, the Help America Vote Act, we had a national debate over voter identification. Bush versus Gore remains one of the most famous cases in the history of the U.S. law of democracy. Notice that it does deal with some of the themes that we've dealt with throughout this entire course, such as whether there's a right to vote that the court should read into the Constitution, and the proper role of judicial authority in settling election disputes. All of those concerns that were raised, for example, by Justice Frankfurter in those early one-person vote cases, fear of descending into the political thicket, well, there was no thicket that was thicker than the 2000 presidential election controversy.